All right. Well, it is 3 o'clock, so we'll go ahead and begin now. All right. Again, welcome everyone, and thank you for joining us for today's webinar, Pretrial Strategies for Child Abuse Cases. Today's webinar is brought to you by the Association of Prosecuting Attorneys. Their contact information can be seen here. My name is William Moore, and I am with OJJDP's National Training and Technical Assistance Center. As your technical host, I would like to take a couple of minutes to discuss a few features of the Adobe Connect platform and provide a few announcements to keep in mind. Please note that today's webinar is being recorded. For those wishing to download a copy of the PowerPoint slides and other important documents, you may do so by locating the handouts pod directly above the chat area. Here, you will also find an FAQ for webinar participants that will likely address any technical related questions. Click on the name of the file and then click the download button. At the end of today's webinar, there will be a Q&A session where the presenters will address some of the questions posed during the presentation. Please type your questions into the chat box as they arise. Please note that this next part is only for individuals who are viewing today's webinar in a group. For those of you participating in today's webinar as a group, please take a minute to help us count. Go to the chat window and type in the total number of additional people in the room with you today. If you are viewing alone, there's no need to type anything to the chat pod at this time. Also, please be sure to download the group validation form in the handouts pod and send to the email address on the slide if you wish to receive a certificate for others in your group who aren't signed in. Following today's presentation, we will have an online evaluation after today's presentation, so please take a few minutes to provide feedback. I will now turn it over to our moderator, Mary Sawicki, for today's webinar.
Good afternoon, everyone. My name is Mary Sawicki. I'm a senior attorney with the Child Abuse Prosecution Project here at the Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., serving prosecutors as well as their law enforcement and community partners. Thank you for joining our Child Abuse Prosecution webinar today. Today's presentation, Pretrial Strategies in Child Abuse Cases, will be presented by Audrey McCormick, Trial Team Leader of the Special Victims Unit of the Jackson County, Missouri Prosecutor's Office. This presentation is made possible by Grant 2019-CIFX-K001, awarded by the Office of Justice Programs through the Office of Juvenile Justice and Delinquency Prevention. APA is very appreciative of their financial assistance and commitment to improving the justice system. Points of view or opinions in this presentation are those of the presenter and do not necessarily represent the views of the United States Department of Justice and the Association of Prosecuting Attorneys. I will now turn it over to our presenter, Audrey McCormick.
Thank you, Mary. Good afternoon, everyone. As Mary and William stated, I am with the Jackson County Prosecutor's Office in Kansas City, Missouri. And my hope today is to be able to provide everyone some helpful tools in the time leading up to trial. I think a lot of cases can be won or lost in the pretrial phase. And so hopefully there are some tips and pointers here, both for those of you that might be a little bit more experienced and those of you that are newer. Some basic reminders, for probably most of you, these are just reminders. Our cases have to be charged based on admissible evidence and not based on emotion or the victim's wishes. And I think that can sometimes be difficult with our cases, especially because of the subject matter that we're dealing with. I think for some of the younger attorneys especially, you may not be fully aware of all of the different enhancers that might be available to you, and it is well worth your time and effort to go through and make sure that you are aware of all of the tools that you might be able to put into your arsenal. And I think as a senior attorney, your role is to help make sure that your younger attorneys are familiar with some of these tools. I know at least with Missouri code, things can be tucked away in all different places, and it's not necessarily neat or logical all of the time, but important nonetheless. So some of your enhancers and aggravators, I think number one is going to come from your criminal history. I'm going to talk a little bit more about that in a minute, but spending the time to go through criminal history can really help or provide you a lot of ammunition as far as charging goes and a lot of different choices. Do you have different enhancers based on the conduct? Is it enhanced because there's a weapon? Is it enhanced because there's injury, or it's a pattern of activity, or it was torturous or wanton or vile is what we use in Missouri? Maybe that victim's age might enhance the charge, the severity of the charge, or their special status as maybe a family member, or maybe they're, excuse me, someone who is either physically or cognitively disabled. That might be able to enhance your charge. Always keep in mind what your sentence service might look like. If you have a certain percentage that might be attached to that crime, is it non-parolable? Do you want to start with a lesser and maybe help that, or it might help you negotiate? Or do you want to start off a little bit more severe because of the nature of the offense? In Missouri, there are certain offenses, especially sexual ones, that require mandatory consecutive time, and using those to your advantage. And then if you've got multiple victims or you have multiple instances of criminal conduct, how much should you charge? Should you charge, or can you charge multiple victims in one case? Do you think that your case might survive a motion to sever if it comes to that? Do you want to add all the different types of crime that were perpetrated on this particular child? Think about the story that you want to tell to the jury. And maybe there is a charge that is a little bit weaker than the others, but you want to keep it there so that your victim can tell the full and complete story to the jury. Moving on to some additional charging considerations, as I mentioned, the criminal history. I think this is very important. And I know different offices have different resources available to them as far as investigators and everyone that can find information for them. But there is a lot of information available to us as prosecuting attorneys that's available on a public platform, essentially. Your law enforcement and investigators should have access to the obvious, which is their databases. But take the time to speak with your local child protection agency to see if maybe your victim has hit their radar once, or maybe even your perpetrator has hit their radar. Make sure that you look into the locations where your defendant may have lived or may have committed other crime. A lot of states and sometimes cities or other municipalities, they have created public search platforms. I know Missouri has one. We call it CaseNet. The feds have one. It's called Pacer, where you can actually go on and type in their defendant's name and see if they've had any other run-ins with the law. But going and kind of tracking where the defendant lived, you might start to figure out, well, my investigator or my law enforcement agency didn't pick up that there was this other case because it either got dismissed or it never actually got to the point of filing. Or maybe you had a more severe case that was pled down to something that appeared less severe. And I think it's worth the time to contact those jurisdictions and see, hey, can I get a probable cause statement for that offense? Because if there's any indication in there that there's an offense involving a family member or your child or another child, you might be able to utilize that later to strengthen your case. You also might be able to figure out that there's other pending matters. The way that we are collecting criminal justice information at this point is obviously much better than it used to be, but it's not a perfect science. I mean, it all does require humans to sit down and put in data entry. And some jurisdictions are more advanced than others. So if you just get a printout from your database, don't assume that what is on there is the full and complete picture, and take the time to go and see if there's other abusive history, child abuse neglect history with your defendant or your victim. And I think another valuable place to look for this information is going to be your victim and their family. Hey, tell me a little bit about this defendant and what you know about him and his family and his history. Are you aware if he has any other run-ins with either law enforcement, or what about CPS? And looking for orders of protection, which might be a little bit trickier depending on your jurisdiction because those might be closed records. But again, in speaking through some of the family members, you might find, hey, I actually had to go get an order of protection against him for myself and my kids because of a prior abusive incident. And then at that point, you have more records and more documentation of an abusive history, which could potentially enhance your charge, it could strengthen your case, or it could enhance the sentence at the tail end. So moving away from your charging considerations into the litigation strategies. My motto is that you should be engaging in your motions practice early and often. There are lots of benefits that come from engaging in litigation and very few negatives. It can be time-consuming, but it really helps to narrow down the available defenses that the defense attorney might present. It might enhance the strength of your case if you start getting some good pretrial rulings, which obviously could either help you with plea negotiations or at least set you up really well for trial. But I think something that's overlooked is you need to educate your court. And most judges are not sitting before a specific type of case. They sit before all types of cases, and child abuse and neglect cases may or may not come along in your jurisdiction all that often. And they may not have a lot of familiarity with the issues that are going to arise in your case. And when you address these issues pre-trial, they're not having to make these decisions on the fly, which can sometimes lead to less favorable rulings. So it's really a time to start priming your court, priming your judge, getting them educated, and hopefully pulling them onto your side before you ever get to the point of selecting a jury. When you are filing a case or when you are first assigned to a case, take the time to sit down and figure out, are there loose ends from my investigation that I need to wrap up? Because as you all are all aware, some evidence it might disappear. Things like your social media presence and things like that, if you don't get protective orders or if you don't get preservation requests in early, it might be gone by the time that you're getting close to trial. So look to see if there's any additional search warrants that need to be executed now before things get stale and maybe the court finds that you don't have probable cause to go in and do execute a search warrant. Are there any additional samples or things that you would like to collect from the defendant? Here in Missouri, we can do this really at any time pre-trial, get blood, fingerprints, DNA, and we can even have the court compel the defendant to submit to FTI testing for certain diseases, which may come in handy if you have a defendant who might claim that he either has a disease and the child didn't, therefore he's innocent, or if the child has a disease and you don't know if he does or if he has, we can force testing for that. And as I had mentioned, additional preservation requests and protective orders for your phones and social media, which or more recently, we're getting a lot more information and evidence, and especially corroborating evidence for our child victims through some of these social media and technology outlets. So this means taking a detailed look at the totality of your case early on and not waiting until the very end when you're a month away from trial and scrambling. One of the main reasons for your motions in limine or your pretrial motions practice, in my opinion, is to kind of expose the defense as much as you can. A lot of the times we can have a defense kind of sprung on us or not necessarily know exactly what the defense is going to be in our case, but there's only so many types of defenses in these types of cases, and at least trying to get rid of a couple of them early is always beneficial. So The common ones are, we call it Saudi here, some other dude did it, and that's going to force the defense to kind of expose themselves a little. If you're going to point the finger to someone else, well, at least now I know that and I can prepare for that. But they also need to make the connection between how this other person supposedly perpetrated the abuse for which the defendant is charged. And they're going to have then have the burden shifts, and it's going to be on them to prove that. And in doing that, they are going to expose some of their strategy and some of the information that they might have otherwise withheld until you got to trial. In Missouri, we have mistake of age and consent as some affirmative defenses, but that depends on the type of crime. You know, is it a strict liability crime? And what is the age of the child that we're dealing with? But the good thing about mistake of age and consent is if you're going to go with one of those defenses, I want to know that early, because that means you're at least admitting to the conduct for which you are charged, and that's going to make my job maybe a little bit easier. Another common one that we see is like the sexualized child, especially for our older youth and teenagers. There should be motions in limine to keep out any prior bad act or sexualized behavior as it relates to your child victim. And if you can't keep it out in its totality, at least limit it, and you know what's coming in, and you're able to prepare for it, and you're able to prepare your child for it if that's going to be an issue. The nullification issue, especially with physical abuse of probably your older or bigger kids, well, he was just out of control. I was just trying to discipline him and try to get the jury to just not care. And if that's going to be their defense, again, something you want to know early so that you can figure out a way to make the jury understand that this is important. It might also expose the strategy of going for a lesser included offense and making sure that you've done your due diligence to figure out what are going to be your lesser included offenses for your crimes which you have charged, and start making strategic moves to either minimize the availability of some of those, or making sure that you have a strong foot forward on getting the defendant convicted as charged versus your lessers. The number one most common is I didn't do it, and that, again, the pretrial litigation might bring out that, well, we're not going with any of the other ones, he just didn't do it. As I had said, it shifts the burden a lot of times, it exposes them, and it hopefully can commit them to certain types of conduct. Otherwise, if you're going to say someone else did it but I don't know who, well, that's all irrelevant, it's prejudicial, it's misleading and confusing. And at the point where you started to litigate some of these issues, you're seeing some of the weaknesses or seeing some of the areas in your case where you can strengthen it and start to identify your expert witnesses or other records or exhibits that you might need to bring forward. And that all needs to be done early and in advance. Some of the other just general motions in limine or things to exclude pretrial, any of the defendant's self-serving hearsay testimony should be motioned to keep out. If there's going to be improper character evidence presented either by the defense witnesses or the defendant themselves or the defense attorney trying to elicit that type of information from your witnesses, it should all be left out. I see a lot of times defendants who want to bring in his family or friends to say, he is such a great guy, the child was such a troublemaker. And that should be prohibited, at least the portion about the child either being a liar or other bad character traits that are not relevant. That should all be left out. And then in the event that either the defendant or his witnesses or the defense attorney decide to violate that motion, hopefully you get to ask the judge to not only strike that information, but maybe give a curative instruction to your jury to say, hey, they just messed up, they just did something wrong. And I think that helps to make the state look like you're rule followers and you're you're presenting your case by the book, and they're trying to pull some shenanigans, essentially, in order to try to get a leg up. If there's any other irrelevant issues that you identified during the process of your discovery and pretrial litigation, don't be scared of the motion in limine. It might get denied, and that's okay. But better to have tried And then at the same time, if you want to bring the issue back up during trial because circumstances have changed a little bit, again, your court is already primed on the issue if you're going to relitigate it. All right, we've talked about basically trying to take down some of the defense strategies, but pretrial motions practice also enhances your case or can enhance your case. If you are working on a case involving a child, there's a high likelihood that you might have some disclosures by that child, and look to see if in your jurisdiction there are some special exceptions to the hearsay rule related to children's disclosures. In Missouri, children who make disclosures about abuse when they are under the age of 14, there's a special exception for it. We just have to have a pretrial hearing on it to ensure that the statements are reliable. In the event that you don't have a specific child hearsay exception, some of the other common ones are present sense impression, excited utterance for the purpose of medical treatment, and to explain the present state of mind. Again, it's better to litigate those hearsay issues early because if you are successful, that might be a good tool in plea negotiations, or at least you know before you go into trial, I know that statement is going to come in. I can rely on that. Look to see if your jurisdiction allows certain propensity evidence. Here in Missouri, we have a constitutional amendment that allows propensity of the defendant committing a crime against another child that can come in. And so that has been a very helpful tool for us. It could be sexual abuse. It could be physical abuse. It could have happened 5 years ago. It could have happened 25 years ago. And that's the type of information that we're allowed to bring in at this point to help corroborate our child victim and present to the jury that the child is telling the truth because this is someone who has done this in the past. If you don't have something specific to child abuse cases that allows propensity evidence to come in, maybe you have more of a case law exception built in your case law. We have what we call mimic, which is propensity to help explain the defendant's motive, their intent, to show that this is not a mistake, to confirm identity, or to show common scheme or plan. If you are able to get in some of this propensity evidence, it's helpful to figure out how exactly is that going to come in. Does this person have a prior conviction for child abuse? Okay, we're going to use a certified copy of that prior. Or maybe it was uncharged bad acts. Well, we're going to bring in the victim of that other crime, and they're going to come in and testify. Or maybe it was the same victim as my present case, and they're going to be able to testify about all of the abuse that they've suffered, whether it is charged or uncharged in our case. Maybe we need to come up with a stipulation that all the parties agree to. Again, it helps to know exactly how that evidence is going to come in. Identifying what needs expert testimony, which I can't really think of a case involving a child victim that doesn't need some type of expert testimony. Not that you necessarily need to go seeking for experts. A lot of our multidisciplinary team members are built-in experts and have worked on these cases, and those are the people that we should be utilizing to help explain to the jury some of the more difficult issues in our cases. Medical experts, especially when we're dealing with child sexual abuse cases, making sure that they are there to explain anatomy, basic anatomy, using diagrams to show the jury exactly what the female genitals look like and what they're called. Medical experts are really important to explain why normally there is not going to be any injury. Maybe you need to explain issues involving sexually transmitted infections. You may need to have a therapist or some other psychological or emotional expert to talk about why your child is behavioral or might look like a bad seed, to show that their behavior is related to being abused, not because they're a liar or making this up. I think the disclosure process is usually a pretty big one. As most of us are aware, when a child has been abused, they don't tell right away. And so to have someone there to explain why that more often than not, children are going to hold out on this information, what the environmental blocks might be, change in in family status. Maybe they're scared, threatened. I think that's important because I think the knee-jerk reaction for most people is, well, when you're hurt, you immediately go run and tell. And so I think it's a little bit counterintuitive to think delayed disclosure is normal until you have your expert up there to testify about it. Child development is another important one. A lot of our kids, especially our younger ones, are going to think in a concrete manner, which is much different than how an adult thinks. And obviously your jury is going to be made up of all adults. And so being able to make that link to the jury that a child does not think the same way as you, and that's based on just normal child development, is going to help explain away why a child maybe said something that an adult might think is a little odd. So being able to use your doctors, your forensic interviewers, your social workers, nurses, and even your family members. They could potentially be an expert in that particular child and their behaviors. And for any of the individuals that you think you might be utilizing as an expert or on an expert topic, brace them for a Daubert challenge. Depending on your jurisdiction, those might be a little bit more common than others, but we get a lot of Daubert challenges in our jurisdiction. Not a whole lot of them are successful, but we usually have to go through the process of showing the court that the person we've designated as an expert is in fact an expert in the field for which they are going to be testifying about. The other important thing with your expert is to try and get them prepared for what the defense is. Because if they can look just as credible during cross-examination as they do during your direct examination, that's great. And if you know that there's going to be a study or some weird fact or anecdote that the defense attorney is going to throw at them during cross-examination, prep your expert for it so that they can handle it with ease and come across as extremely knowledgeable, and essentially that defense attorney might be trying to trip them up, but there is nothing that they can't handle, and therefore they are credible and you can trust what they are saying. The last kind of area for this webinar is victim advocacy strategies. This is a piece that our office works very hard to keep our victims engaged in the process. And there's many reasons for it, but the main reason is that this process should hopefully find justice for them. And they should not be subject to the criminal justice process, but hopefully gain some type of empowerment through this process. So when possible, I think it's a good idea to meet with your victim and their family prior to charging, just to give them an overall view of what this process looks like. That way they can get familiar with the attorney that they're going to be working with, your office, maybe your victim advocates that they're going to be seeing over the next year or two or longer. It also gets you familiar with your child victim. Maybe your child responds to different ways that you are saying things, or maybe they have a developmental delay and you need to work on ways to communicate with them more appropriately. Maybe you learn their favorite hobbies and what's going on with their lives, and you're able to carry on a conversation with them and build that rapport. And I'm sure most of you know that when forensic interviewers and social workers and therapists are starting to work with a child victim, that first stage and as it continues on throughout their entire work is rapport. It's extremely important. And so if you are meeting with your child victim from the very beginning, you start that process early so that by the time that you get to having them sit on the stand, they know you, they trust you, they're comfortable with you. The meeting with a child can sometimes be a little bit tricky about, well, how much do you tell them? How much detail do you go into it with them? I think that's going to be based on your training and experience and really just your gut on the situation. Younger children probably don't need to know as much, but maybe your older children, your teenagers, it's important for them to know what's going on. And so maybe you give them a little bit more information or a little bit more detail. one of the other things is, what do they want to see happen, and trying to figure out what is their expectation for what is going to happen during the criminal justice process. Do you have mom and dad who come in and are like, I want him to go to jail for the rest of his life, and you know that that's not what is going to happen in this case, and being able to temper some of those expectations so that they are not disappointed by how the process is working out, that you are keeping the bar at a reasonable level and try not to pump them up too much with pie-in-the-sky expectations. It's important to take the time to answer all the questions presented to you. And I know sometimes they get repetitive and sometimes they seem like silly questions, but for most people, this is the only time that they are going to have ever interacted with you or your office or the criminal justice system. And it's important to keep in mind that they don't know what's going on, and they are working with you based on one of the worst days or days in their life. And so taking the time to listen to the good, the bad, the ugly, again, helps to build that trust and that rapport, and that's going to keep them connected to you. During those initial sessions, make sure that your kiddo's at least been offered therapy services or referrals. This process is not kind to any victim, but it is very stressful for our little ones. And so having that additional support in place as we move forward towards trial will hopefully help them. You may also get some additional disclosures during those therapy sessions, and then you've gained a new expert witness potentially, or at least another corroborating witness. But primarily, the goal is to help minimize the amount of trauma that a child has to go through because they are subject to this process. Some of this information on this slide is a little repetitive, but when it comes to talking with your victims and their family, if you are available, they are more likely to reach out to you. If they start to experience maybe some victim tampering issues, they might feel comfortable enough to come to you and say, hey, we're really scared, this thing is happening, can you help us? Or if they need other services or other help, you can be there to help them through the process, and then they know that you will be there for them. And in many cases, some of our victims and their families are a little bit more transient, and they don't live in one place for the entire time, and they don't even keep the same phone number for more than a month or the same email, and they can be very, very difficult to get a hold of sometimes. But if you are a person who they trust, who they know is working for them, and they're more likely to reach out to you, then you're going to be able to maintain contact with them, which is vital. If you need to make travel arrangements with them, get that in place early, and just continue to make sure that you're having some face-to-face meetings with your family prior to trial. Here in Jackson County, we have a kids court program that we do biannually. We send an invitation out to all of the victims, child victims in our cases and their families to come to the courthouse for a day, and we put on a kind of like a mock criminal trial that involves someone stealing the hat off of a giant teddy bear. And they all get to kind of see what a courtroom looks like, and they get to all be a judge, and they all get to be a witness, and they all get to be an attorney and ask questions. And it's kind of silly, but it's a back way into prepping them for trial. And we talk about some of the basic tenets of testifying, number one being tell the truth, and getting them kind of prepared for that. So if that's not something that you all have instituted in your jurisdictions, we have found it to be very helpful in our reducing some of the stress and anxiety for our kids, and quite frankly for their families as well, when they come in and they kind of see how this all may unfold. As attorneys for these cases, we have an obligation to move these cases quickly. They don't get better with time. We may lose evidence. We may lose our witnesses because of the fear or trauma or relocation. So minimizing the amount of continuances, litigating early to minimize the amount of continuances, trying to object if you can to continuances to keep things moving is in the best interest of you and your victim. In Missouri, cases involving a child victim or witness are given mandatory priority over every other case. And so for judges that may not be aware of that, we ensure to make them aware of that. And even if it is not mandatory in your jurisdiction, explaining to the court the amount of trauma and stress that a child must continue to endure as this case delays on is something that they need to be mindful of. So even if there are continuances, they're going to be short. Finally, preparing your child, making sure that you at least tell them what is going on, whether it's for a deposition or a trial. Make sure that they come in early so that they can be comfortable and meet with you, but not too early so that they're not just sitting there kind of stewing in anxiety. Making sure the simple things, have they eaten, have they used the bathroom, are they comfortable, have they slept? And make sure that you're explaining the process to the child in developmentally appropriate terms to minimize the unknown, because for kids, the unknown is scary, and this process is one big unknown for them. But try to give them some examples of the types of questions they're going to be asked, explain to them who's going to be in the room, and that telling the truth is the most important thing, but it's also okay to say, you don't know. Speak to them generally about what is going on with the case. If you start to get the vibe that the child may not remember some of the details of their earlier disclosures, you'll have to weigh the pros and cons of having them sit down and either watch their forensic interview or read through their prior statements. Obviously, the pros would be that it might kind of refresh their memory. It might bring back some of those details. The con is going to be the defense attorney is going to ask, what did you do to prep for this deposition or prep for trial? You met with the prosecutor, didn't you? They showed you the video, didn't they? And it's going to be argued that the child was then coached and couldn't rely on their own memory. So I always encourage people to, if you can avoid having a child review their statements, that might be beneficial to you. But if it ultimately is going to be more beneficial to have them watch it despite the coaching allegation, that is the time to do it, is well in advance of deposition or trial. Make sure that you take the time to take them to the empty courtroom and explain to them who's going to sit where, and that there are going to be officers or other security present. And it's going to be important to let them know that the defendant's going to be present. You don't want your kid to walk into the courtroom during trial and not expect to see the defendant and see him and then freak out. So let them know that the defendant is going to be in the room, but that they are safe and that the defendant doesn't get to ask them questions. Make sure you let them know that they can take a break if they need to. Obviously, that's going to need to be cleared by your judge. And then if there's someone that they want to be present in the courtroom, obviously a non-witness, maybe it's grandma, maybe it's a friend, someone that they can look at, make sure you identify that person early and that travel arrangements are made for that person as well to help comfort the child during testimony. And then maybe they need a comfort item. Maybe they have a teddy bear or a blanket or something else that they want to hold on to while they testify. Here in Missouri, we have to file a motion at least 30 days in advance as it relates to a comfort item to ensure that the item might not be too prejudicial and that the defendants had an opportunity to object to that. But keep those things in mind when how do I make this the least traumatic as I can? How can I provide some comfort to my child as we go through this process? If you have a child that you're working with and you start to identify that they are going to be unable to testify due to trauma, you might be able to file a motion to find them unavailable. Some of the evidence that supports that might come from their teachers or therapists or parents or a psychologist. Here in Missouri, we don't necessarily need, quote-unquote experts. A mother or a father or a teacher might be able to lay the foundation for this child, if they are to testify, is going to suffer some type of emotional break or something like that, and it could be detrimental, like permanent detrimental for them. If you are able to make that request in your jurisdiction, you still always have to consider your confrontation clause issues. confrontation clause in Crawford basically comes down to, is it testimonial or not testimonial? What is the primary purpose of the statement or disclosure? You know, when it comes to parents and teachers and therapists, those, at least in my experience, have been determined to be non-testimonial statements by the child. But when you start to get into law enforcement and children's division, forensic interviewers, those are more testimonial, so you're going to have a confrontation clause issue there. But if you have an outcry witness and it's a parent or a teacher and your child is just not going to be able to get through testimony, maybe you try to make the motion, declare them unavailable, and see if these non-testimonial statements can come in. Or if you do have testimonial statements but you have an exception to Crawford, like forfeiture by wrongdoing, maybe you try and get that established nice and early. If you are able to present the child's statements without having to present the child, that is a powerful negotiating tool and something that you want to know well in advance of trial. So those are my basic tips and pointers for pretrial strategies, and I think at this point we are turning things back over to Mary for questions.
Thank you, Audrey. If anyone has any questions, you want to type them into the chat now, and we can address them. If anybody has any questions at all? While we're waiting for that, Audrey, I have a question.
Yeah.
What type of experts, do you usually use in your cases, and maybe you could, elaborate on that?
Sure. I think the most common expert that we use is our forensic interviewer, because in most of our cases we're going to have a child who has gone to our local child protection center and had a forensic interview done. Most of our forensic interviewers have backgrounds in social work or degrees in psychology on top of the additional experience that is required to be a forensic interviewer. So we usually utilize them for disclosure process, for child development, talking about grooming behaviors that are traditionally seen in child sexual abuse cases. So we probably use them the most. Medical testimony would probably be secondary, I think, because either you've got an injury and you need to explain that, or you don't have an injury and you need to explain that.
Okay, great. We have another question, which is, doesn't prior bad acts of victim witness go to credibility?
I guess my question is credibility of whom? The victim or witness?
I assume that's what it means. Yep.
Okay. And so if we're talking about prior bad acts, at least here in Missouri, you're not allowed to use a single prior bad act to help the defense attack credibility. You're only allowed to use general character for truth and veracity, if that makes sense.
Okay, we have another question. Can you share a defense Dobert motion example?
Oh, sure. Just email me. I'll give you lots.
Okay, next question. How is a treating therapist not vouching improperly?
So we do have to be very careful to make sure that your experts are not vouching for your specific child. And the way that our courts have basically drawn the line in the sand is that you are allowed to use your expert to talk about things generally. For example, if you have a therapist, in my experience, children normally do not delay disclosure normally do not immediately disclose their abuse because of many factors, including a change in family dynamic. Maybe they were groomed, maybe they were this. And so they give all these generalities based on training and experience. And then way later in your direct is when you start to just ask general fact questions about your particular case, and you do not tie the therapist's training and experience to the child's experience during that direct examination. You do it during closing.
Okay, thank you. Another question. Do you meet, Audrey, with all of the families before charging, even those cases you don't charge?
We do not face-to-face meet with everyone, but in Missouri, we actually have a Victims' Bill of Rights that is promulgated both in statute and our Constitution that says the victims have a right, well, many rights, but one of them is to know what the charging decision is. So at an absolute minimum, we are calling every single family if we still have good contact information for them.
Okay. And any other questions that anyone else has? Please type it in. If anyone has anything else, we'll just wait a second. Okay, I don't see any other questions. Thank you so much, Audrey, for a very informative webinar. Thank you all that are listening for attending this webinar today. And William, do you have any final comments?
Yes, I do. And thank you, Mary. And again, thank you to everyone who's joined for today's webinar. We just have a few quick, brief announcements before we adjourn. The first thing that I wanted to mention to all of our audience members is to please know that you can contact OJJDP's INTAC on the contact information on this particular slide. Also, don't forget to check us out on Facebook and go and like us on Facebook at OJJDP-TTA. If you'd like to get in contact with OJJDP, you can contact the OJJDP Help Desk, and this includes for any handouts or outstanding information that you need access to. You can contact OJJDP at ojjdp-tta@usdoj.gov or even on the website on this slide. Also, don't forget to sign up for the OJJDP Juve Just listserv. Do you have a training and technical assistance need? Well, if so, please visit OJJDP's TTA 360 platform. Here, you can submit a request to receive TA assistance. Please take a few seconds to review the disclaimer here. And last but not least, please remember to be sure to take a few minutes to click on the link here and complete the online evaluation. Again, thank you all for joining us this afternoon. Have a great day.
Thank you.